CEO of Hello Divorce and certified family law specialist. I've been practicing divorce law for 15 years. And if you are in California and considering getting a divorce, the first form that you will need to fill out is the FL-100. So this is just a tutorial on how to complete it properly. I also want to remind you that if you are a Hello Divorce member, you can use our guided interview to complete your forms. It's simply following step by step. And once you're done and you've completed it, your forms will instantaneously pop out. And if you'd like us to file and serve them for you, we can. Otherwise, there is instructions on our web application, the Divorce Navigator, on how to do that. But let's get to the FL-100 itself. So, top left corner, if you are representing yourself, you are going to put in the information for your divorce. You don't have a bar number. You're simply going to put your name, your street address. You cannot use a P.O. box. You can use another address, however, if you don't want to use your own address, but understand that everything in this case is then going to go to that address until and unless you file a change of address form. So unless there is a safety issue, I would strongly consider putting your own address here. I assume, as most people, you don't have a fax number, and if that's the case, simply not applicable is fine. And with the courts slowly starting to adapt to technology, it's a great idea to put in your email address. If a court clerk wants to contact you, that is a wonderful way for them to do it. Under attorney for, well, if you are representing yourself, you are not an attorney. So here you can just say pro re or proper or self-represented, or you could even do not applicable. The next thing you need to do is put the county of the court that you are going to be filing in. So if you've lived in a county for at least 3 months, you can file in that county. Those 3 months have to be just before you're filing. So in my case, I live in Alameda County. If you don't know the address of your court, you can go to the Superior Court, California Court website. You can type in your zip code to find your local court. You can also go to the county court website and see where, in fact, they file family law actions. So once you get there, you're going to then go to the petition and respondent piece. And the petitioner, since you're the one filing, is you. You want to put in your legal name, not your maiden name, but your actual legal name if you changed it, and the respondent's name, his or her legal name as well. Then you'll need to choose whether you're asking for a divorce, a legal separation, or a nullity. If you're confused about these options, we have tons of resources at hellodivorce.com, so please check them out. But most people are going to choose divorce of their marriage. If you are in a state-registered domestic partnership, you'll also want to check that box as well. You can dissolve both your domestic partnership and your marriage at the same time. Otherwise, leave it blank. And then you'll want to check all that apply. So if you're married, that's an easy check. If you were domestic partnered, either in California, you check B, or outside of California, you would check C. And then we need to check who has been a resident of the state for 6 months and who has been a resident of this county, the county that you put above, for at least 3 months. And it could just be you. Maybe it's both of you. Maybe it's just respondents. 2B and C are pretty self-explanatory. If you have a domestic partnership outside of California or it was established in California, then you'll want to check those boxes. Next to the statistical facts, so you'll definitely want to check 3A and put the date of your marriage and your date of separation. Now, date of separation is super important because it can affect how long and how much you pay or receive in spousal support and how property is divided. So again, we have some great resources on Hello Divorce about date of separation. You can consult with one of our legal coaches or a lawyer in your locale if that's easier. But date of separation is generally the date that one or the other said to each other, hey, that's it. This marriage is over. I want a divorce. And then your conduct continued to affirm that decision. Maybe you moved out. Maybe you didn't move out, but you changed rooms and you hired a divorce attorney, or you told your spouse that you'd like a divorce and you continue to act upon that. So you'll add that there. And then you can skip down to 4 if you are not domestic partnered. And you'll want to click whether or not you have children that are minors or not. If you do, there's going to be an additional form that you need to do. It's called the FL-100, and you can find that by clicking right here on the FL-100. And if your child was born before you got married, you'll need to check 4E as well. So then every page you're going to want to fill in the petitioner and the respondent like you did on the top of page 1. Otherwise, your forms could be rejected by the clerk, meaning not filed. When you hit 5, you'll probably want to say that the divorce is a result of irreconcilable differences. That's what most people put. If you have a question about this, great idea to talk to a lawyer. And then for child custody and visitation, you don't need to get that detailed right now. So simply clicking joint or sole is fine. If you'd like to be more specific, you can attach one of these forms. Google the form number and you will be able to find it. But unless you expect to do a divorce where your ex is not only not going to participate, but won't even agree to sign something or work with you on an agreement, then you'll want to be as detailed as possible. So then you might want to check one of these boxes. Child support is a given. Whether or not you guys decide to actually do child support, there's nothing really to check here. Just understand that child support could be ordered. Then you'll head down to number 8 to decide about spousal support. And we have to decide what we're going to do for each of you. So is spousal support going to be paid to you or to your spouse? Or do you want to terminate the court's ability to ever award it to either one of you? Or do you maybe want to reserve on it and sort of deal with that issue later? One thing I will say is that if your spouse is not going to participate in the divorce at all and you expect to move forward without his or her agreement, and you have a long-term marriage, a marriage of over 10 years, then you're not going to be able to click that terminate box. You will have to check the reserve box. Now, again, you want to be as specific as possible if you think your spouse is not going to cooperate at all with the divorce. Simply turn his or her back or they're missing. But if they're not, if you think they're going to cooperate and you're going to be able to work towards an agreement, then I would say you want to be really general here. You just want to acknowledge that each of you have some separate property that we likely need to assign. Separate property meaning any property that you acquired before marriage, after separation, or during your marriage by gift or inheritance. So that's simply what I would write here. I would say that all property acquired before marriage, after separation, or during the marriage by gift and or inheritance. And we want to confirm that to you. Moving right along, petitioner and respondent, complete that again. Same thing for community property. Be specific if it will be a true default. Otherwise, you can leave it pretty vague and say, that's another issue with these forms. They aren't great. Our forms are awesome if you use our software, and you can edit them. But the forms that are provided directly by the court sometimes are a little challenging to edit. But what we will say here is all property and or debts acquired during the marriage and before separation. All we're doing here is preserving our rights. You guys might decide that you want to just each take your own community property. That's fine. We're not determining it yet. We're just acknowledging that it exists. Other requests, you may each be paying for your legal fees. You might not know yet, but it can be a good idea to check both boxes. Each of you will pay at least something. We won't know what that is yet, but that's okay. And then if you want your former name to be restored, your maiden name at the end of this divorce, then you'll want to put in what that maiden name is here. Then you will date, print your name, and sign. And the only thing left is that FL-105 if you do have kids, and the FL-110, which is super easy to fill out, that is the summons. Then you take all 3 documents, and it will then be ready to file with your county court. So I hope this helps. Let me know if you have any questions. You can email us at hello@hellodivorce.com. Thank you.